Hi, welcome to BTM Afrika. My name is NYDJ. Today on BTM Afrika, we're bringing you conversations on legal issues like we did the previous time. We're going to have a conversation on bail. Many a times we hear about bills, we hear some of the figures that are being quoted. People will say, hey, will this person get this money? Will this person get this property? How are they going to be able to raise all this so that they get their freedom? Bail is something that is of importance to us, and so today we get to look at it. Like I keep saying, on this channel, we break complex legal issues and make sure that they are easily understandable by everybody, including you. So welcome to BTM Afrika. My guest today is lawyer Dennis Oppong Wiafe. He is with Obeng Menu Law Firm here in Kumasi. Like I keep saying, once you've been through the walls of KNUST Faculty of Law, he's had an impact on you, at least for the past 6 or 7 years. If you've been to the Ghana School of Law Kumasi campus as well, he's had an impact on you. So it's important that you pay attention to this. And he's everybody's favorite. He is my personal lecturer. He's guided me through what I do to where I am today. So he's my guest on BTM Afrika. But before we get into the conversation, let's go for this quick break. All right, guys. So in the previous episode, we had a conversation about the rights of individuals. We talked about the rights of a suspect. We talked about the rights of accused. We talked about the rights of a convicted person. Now, all these, if you missed it, you can actually check the previous video and get to watch it so you understand. Today, we are looking at bail. And the question is, what is bail? Who is entitled to get bail? Do the courts have any say when it has to do with bail? Conditions of bail. What are all these things, and what are even the different types of bail available to individuals? My guest once again, lawyer Dennis Oppong Wiafe. Counsel, thank you once again for the opportunity. Bail. We keep hearing bail. Somebody's been arrested, has been granted bail. Somebody has been picked up. The person has been convicted. He's seeking for bail. Bail, what is it?
So basically, bail is a concept that seeks to ensure the protection of liberty of persons in the criminal justice delivery system in general.
Okay.
So we have, as we indicated in the earlier session or conversation some time ago, you understand that we have the Criminal Offences Procedure Act that implements or seeks to enforce the Criminal Offences Act and any other criminal offense. It gives the law enforcement agents powers to have hold of persons. And in order to be able to effectively enforce the laws and do whatever they do, you must be with them.
Okay.
You, the suspects, or you, the person, must be with the law enforcement agency. You must be with the court so that they can do their work effectively. Now, if that happens, it means that your liberty is being affected. Your freedom of movement is being affected. So bail is a concept introduced in the justice delivery system to secure the liberty of a suspect, of an accused, and of a convict, pending investigation, pending trial, and pending appeal, respectively. So
Okay.
I'll break them down. So what it means is that at every stage of the criminal justice delivery system, there is right of bail.
Okay.
It means that at every stage, your liberty is being protected one way or the other to give you some freedom of movement, to move away from being in custody of the law enforcement agency. So a suspect is granted bail, an accused is granted bail, and a convict is also granted bail if you satisfy the conditions of the grant of bail.
Okay. So there are conditions to be satisfied.
That is so.
Now, having known that, at least we now know the different types of bail. You talked about suspects. You talked about one that is before trial and then one after conviction and all that.
That is so.
Can you take us through, the types of bail and, what conditions must be met?
Okay, so let's start from doubt of a suspect.
Okay.
We call it police inquiry bail. But they say it's police inquiry bail notwithstanding. It's not limited to only the police granting that bail. So I can say bail pending investigation.
Okay.
I'll call that bail pending investigation, which is usually granted to a suspect. So let me explain from this angle so that your listeners will understand. Now, if the criminal justice delivery system, at the time that they are doing investigation in response to a particular person, the person is a suspect.
Yes.
Okay. When after the investigation, they realize that after their findings, you have committed offense per their investigation, they want to charge you. As soon as they charge you, become an accused. When they take you through the trial and you are convicted, right, you become a convict. You understand?
Yeah.
So with these individuals, a suspect, an accused, and a convict, the law grants them bail. So that's why we have bail pending investigation, bail pending trial, bail pending appeal, because the convict may appeal to the an appellate court. So we have bail also pending appeal.
Okay.
So let me start from the discussion on bail pending investigation.
Yes.
Which is usually granted to a suspect. Now, the Constitution provides under Article 14 that your liberty must be protected.
Okay.
Your personal liberty must be protected as a general rule. Right. Before that, Article 12, Clause 1 has guaranteed the fundamental human right of all persons. Which fundamental human right includes your liberty, personal liberty, and all that. And that fundamental human right must be respected by every person, all the organs of government, every state institution, the courts, the police, any state institution, every authority, every person must respect that right.
Okay.
So, that right, as I said, include your liberty. But if you go to Article 12, Clause 2, it says that the rights are not absolute. For your listeners to understand, it's not absolute. It means that there are instances where your rights may be interfered with.
Exactly.
So, Article 14 saying that you have your liberty that you have to enjoy. When you go to Article 14, 1G, it provides that when a person is suspected of having committed a criminal offense, right?
Yeah.
That person's rights may be curtailed. So if you are suspected that you have committed a criminal offense and they're investigating you, so they have summoned you. It means that if they have summoned you, they may arrest and they may detain you. That may affect your rights.
Right. It means your right of movement and all that
will be curtailed. And it's within the law. Even though generally they shouldn't curtail your right or your personal liberty. But because you are suspected or you are being alleged that upon reasonable suspicion you may have done one thing or the other. They may curtail your liberty. Okay. You understand that? In curtailing your liberty, the law is also aware that they may unjustly or unreasonably curtail your liberty. So they are providing some exception within the exception, where the law enforcement agency must also grant you bail.
Okay.
So that is what the Constitution says under Article 14, Clause 2, which is Clause 2, yes, and 3, which is to the effect that if the police has arrested or any law enforcement agency has arrested, restricted or detained you in respect of any investigation, then you must be sent to court within 48 hours.
That's why you typically call the 48-hour rule.
You must be sent to court within 48 hours. If you are not sent to court within 48 hours, you must be released. That statement released there is what you have interpreted to be that then you must be granted bail.
Okay.
You understand that? Now, before 2015, in the Criminal Offences Act, we had a particular section, Section 96 and Section 7, which made some offences and some matters, if you are caught within them, unbailable.
Unbailable, yeah.
So, some matters like you are being extradited to another country. Some offences like terrorism, piracy, rape, genocide, hijacking, murder, manslaughter. Those offences were deemed to be unbailable.
That meant you could not be granted bail, no matter what.
So that provision was applicable to the court should not grant you bail. So if the law prohibited the court from granting you bail, then the law enforcement agents will not grant you bail.
Definitely.
So what it meant was that then, that 48-hour rule, that if they don't send you to court, they must release you. When you are caught within those offenses, the police will not release you within the 48 hours. Until the Supreme Court, in a case, which I don't want to bore your listeners, Martin Peel was Attorney General number 2, struck out that particular section, which made those offenses unbailable. So what it means is that, unlike bail pending trial and bail pending appeal, which the court may exercise discretion, when it comes to the 48-hour rule, the law enforcement agency does not have the discretion. It's strict. Because in 2018, 2019, the Supreme Court threw Sophia Akufu. That was her last judgment when he was retiring as a judge, Supreme Court judge and as a Chief Justice. Pronounced that the 48-hour rule is very strict. And even made recommendations that there should be weekend court and all that in the judgment.
Yeah.
So the 48-hour rule, there is no discretion.
The law enforcement agencies have no discretion.
That we respect the 48-hour rule.
They can't say we are deciding to either give you the bill or we are not giving you.
Yes, the bill must be given. But where it gets interesting is that they impose conditions. So if you are not able to fulfill the conditions, then they have complied with their constitutional mandate. If you have not fulfilled the conditions, so you are still in custody. It doesn't mean they have not granted you bail.
Yeah.
You understand?
Yeah.
Now, people argue sometimes, it's arguable. I don't know whether you have to take you to the Supreme Court for them to pronounce on it, that Yoko, OSP, NACOB, and all that, you don't have the right to grant bail. Personally, I disagree because when you read, for example, Section 18 of Yoko's Act, Yoko has been given the power of the police in respect of arrest. So if they arrest you, the Constitution has said that if they don't take you to court within 48 hours,
they must grant you bail.
So they have to grant you bail. And in granting you bail, they mostly try to grant the bail in such a way that they impose certain conditions. Now, let me speak to the amount. The practice has been that if they are granting you bail, they must grant you bail to commensurate the value of the subject matter. So if you are being investigated for 50 million Ghana cedis, for example, Miracle Abaji.
Yes.
And they are granting you bail. They'll grant you bail in tune of
the subject matter under which you are being investigated.
If it's 1 Ghana cedi, they will say 1 Ghana cedi.
So they can't charge more than.
Mostly they don't do that.
Okay.
They either go below. If they even go up, it will not be that. But it's within the range of the subject matter that they are investigating.
Okay.
You understand?
Yeah, sure.
Now let me explain why they provide property as justification. So I'll get to that when we are discussing bail pending trial. The bail is a contract. Okay. It's a bond. It's a contract. Before a particular law was repealed, which I'll discuss later, if you provide the condition that if the person absconds and I'm able to provide justification why the person has absconded, I'm able to show cause and they string the board, you have to pay that amount of money. So the amount is not paid upfront. It's when the person fails to appear before the investigating team or before the court, then you pay that particular amount.
That is for the surety.
For the surety.
Okay.
If it's not self-recognizance, I'll explain the two. Now, if before I think 2014 or 13, before that, if you fail to pay the money, the court will issue a warrant for you to be in prison for not more than 6 months.
Okay, so
you the surety.
So somebody has been arrested. I stand in as surety for the person to be granted bail.
And the bond that you sign is that you bring the person.
Yes, and
you ensure that the person appears whenever the person is needed.
And the person absconds.
Yes.
Now I would actually be arrested.
No, first justify.
Why the
first they'll ask you to produce the person. If you're unable to produce the person, you must give reasonable justification why you couldn't produce the person. If it's satisfactory, then they may see how they will assess the situation. If you're unable to show cause, then the bond will be restrained and you'll be compelled or you may be ordered to pay the money. The money that was a bond that you posted.
Yeah.
Pay that money. You understand that?
Yeah.
In some jurisdictions, you have to pay the money upfront before the bill is executed. But Ghana, the money is not paid upfront. Now, under Section 104, subsection 4 of Act 30, then, under Section 4 or 5, I know it's Section 104. If you fail to pay the money at that stage, then the court will issue a warrant under the court warrant for which you may be in prison for a period of no more than 6 months.
Wow.
You understand? But the Supreme Court established that bond is a contract. And if you breach a contract, it try a civil liability, but not a criminal liability. So it's no more a term of, they will not imprison you anymore. So now what is happening is that to ensure that if the person is not able to, you are not able to produce the person, the money that you agree to pay, you are now required to provide justification. Justification is bring landed property, for example, or a property to guarantee, so that if they have those documents and because it's a contract, if you fail to pay, they may fall on those properties to defray the debt.
So that's how come of late you could hear that maybe 50 million Ghana cedis with 2 landed properties. Oh, okay.
You understand? So the landed property, if the person absconds and you have the 2 million Ghana cedis, you pay, they don't fall on your landed property. But if you are not able to pay,
they will fall on the landed properties.
Sometimes they will say the surety should be a public officer because the public officer receives salary. So they may trace.
So they will tap it right from how do we call it? The final. I forgot
from controller.
Exactly.
Where your money is paid from. So the reason why that now they introduce those properties, those justification is because they can no more convict you, and they need the money.
Exactly.
It goes to the state.
Okay.
It doesn't go to the complainant. It goes to the state.
Interesting.
So they are provided means of getting that. The same thing under Section 28, OSP also has the power to arrest and
grant bail.
And the power of the police to arrest. So they can also grant bail.
Yeah.
You understand all that? So what I want to establish is that the 48-hour rule, unlike bail pending trial and bail pending appeal, where the court may exercise discretion, the 48-hour rule, the law enforcement agency does not have the discretion. So now what they do is that they will grant you the bail, but they impose conditions which are so harsh that you may still be
onerous.
there. Yes, that you may still be there.
Okay.
Right. So it's not that, in my opinion, I think it's not far-fetched if you could arrest someone, grant bail, and impose conditions. The conditions are stringent in a way that ensures that whenever they need you, you appear. Because when you run away, the person that signed for you as a surety may be compelled to pay. So the conditions are not there for rather preventing you from moving or leaving, but the conditions are there to ensure that you appear whenever you are because if you don't appear, the consequences are that the monies that they said must be paid.
Interesting. So that is for bail pending investigation. Okay.
For suspects. That one is a 48-hour rule, which is provided in the Constitution under Article 14.
Okay, so at least we've established one, that is bail pending investigation. Okay.
Now we have bail pending trial.
Bail pending trial.
Yes.
So that's before you are...
after their investigation, they believe that they want to charge you for a particular offense, right? Now, before we come into the trial, even the bail pending investigation, after the investigation, the police will charge you.
Yes.
So you become an accused. They can also grant you bail. Some books call that police to call bail.
Okay.
So they will tell you that, so as for they will do investigation, so all that you wrote was your police investigative caution statement. When they want to charge you, you come and prepare and sign your charge statement. So as soon as you prepare and sign your charge statement at the police station, right, or at the Attorney General's office. Or at Yoko's office, by signing your charge, you become an accused.
An accused person.
There they can say, we are taking you to court. We will not let you go home.
Right there.
Because we have charged you. The first bill that we gave you was pending investigation. Now we have charged you, so we are taking you to court. So they can also decide that, okay, we will not detain you. You take you to court, let's say next week Monday or next week Friday, but go home. So they can grant you another bill, which is the police to court bill.
Okay.
So that you move from the house to the courts instead of they being in their custody and they taking you to courts.
Okay.
So you see, this one is no bill pending investigation because they are done with their investigation.
Now you've been charged.
Yes.
So between that period, they can give you.
They can also grant you bail.
Okay.
And ask you to go home, so that when the day that they face for the case to be called in court, you
come from your home to the court.
So some people call this one police to court bill.
Okay. So
it's not a meal bill for discussion.
Okay.
You understand? So that's why most people don't even know police to court bill. All that they know is police bill pending investigation and the others.
Yeah,
you understand that? So let's go into the bill pending trial. So that's why they are done with the investigation. And they've charged you for a criminal offense. You are being arraigned before the court. So you are before the court. Now, unlike the bail pending investigation, which is regulated by the Constitution, the bail pending trial is regulated by the Criminal Offences Procedure Act 30.
Okay.
So Section 96, subsection 1 of that law, the Criminal Offences Procedure Act 30, 1960, is to the effect that if a person appears before a court on any process, the court may grant that person bail.
So the key word here is may.
May.
Okay.
So the may there makes it discretionary. That
so the court can decide to grant or decide not to grant.
Yes. Now, that discretion there was not a discretion for some offenses. If you remember, I mentioned that Section 96, Section 7, certain offenses were not bailable.
Yeah, rape, murder, high treason,
treason, hijacking, piracy. Those high offenses, they were not bailable. So, in those offenses, the court was not granting bail in respect of their discretion, right? Except where it's very under extreme circumstances, maybe on health grounds, then the court may grant you bail in respect of those offenses.
Okay.
But that notwithstanding, the court discretion that it had, right, was limited in respect of those offenses. They were really exercising that discretion to grant bail.
Okay.
But as I said, the Supreme Court has struck out that law. So what it means is that all offenses are now bailable. But there's even some people have criticized that case when they said that, Section 96, Section 7 has been struck out and that now all offenses are bailable. Because another Section 96, Section 7 is not all the indicators that were offenses.
Yeah, that's true.
Like being extradited to another country was not an offense.
Yes.
So when the principle is that all offenses are bailable, it's not
absolute. Like, yeah.
That statement was not correctly put. That's what people are saying. Rather, it should have been all offenses, all matters that fell under
that particular 96.
Yes.
Okay.
Bailable. Right. So let's go on the tangent that all offenses are bailable.
Yeah.
The fact that all offenses are bailable does not mean it's automatic. That as soon as you are arraigned before the court or as you appear before the court will grant you bail. It's not automatic.
Okay.
You must fulfill certain conditions.
Okay, so how does one even go about the bail? You'd have to apply.
So let me also explain. If you see, the 96 Section 1 said anytime you are put before the court. So anytime you are put before the court, whether you make the prayer or you don't make the prayer, the court may consider bail. Okay. So sometimes we say that some courts are courts of summary jurisdiction, some are courts of record. So if you take a court like Circuit Court, High Court, Court of Appeal, Supreme Court, those were their courts of record.
Records, yeah.
Right? Court of record means that their proceedings are recorded. So if you go to the High Court, you cannot apply for bail orally. Like generally, you cannot make an application to the High Court orally. Right? Unless you file a process. One of the exceptions where you can make oral application to the High Court is matters of bail.
Oh, okay.
Because the 96 one says if the person appears before the court. So anytime an accused person goes to court, you can always make oral application
to the judge for bail.
But if the case is not fixed to be heard on a particular date and you want the court to consider bail, then file an application. You understand that?
Yes.
So it could be the district court. The case is not fixed for the court to hear the matter, but the case is before the district court. And you want the court to consider bail. Then you file a formal application to the court. Then the registry will fix a date for the case to be called so that you go and move your application for bail.
For bail. I'm pretty sure our listeners are like, what is going on here? But basically, what Lawyer Dennis is trying to say is that at any point in time, a matter is called before a judge, you can apply for bail. Yes.
Any time an accused appears before a court,
whether
orally or by a motion, you can pray to the court for bail.
However, when that matter is not supposed to be called
before a court
and you want
the court to consider bail for your client,
then you have to file a process.
Yes. So it could be that maybe at the first time the person was arraigned before the court, there was no lawyer. So no prayer for bail was made. Even though a prayer need not be made before a court consider bail. So whether the person has a lawyer or not, the court may consider whether to grant the accused person, but the court has that discretion.
Yeah, so the court may to actually decide.
Yes.
Okay.
To grant you bail, right? But maybe the person was remanded either at the lower courts or the trial courts, right? And you want your client to be granted bail, right? You can apply to that court by motion for bail, or you can apply to the high court for bail, even though the accused is not before the high court.
The high court.
Because under Article 140 of the Constitution, the High Court has jurisdiction in all matters, whether civil or criminal. So when it comes to matters of bail, it's also matters of fundamental human rights.
Yeah.
So even though the accused is not before the court, you can apply to the High Court for the court to consider bail.
Okay.
For the accused.
Okay.
You understand that?
Yes.
So the court also can grant bail. You can also apply to the court for bail. Right. So what are the conditions that must be satisfied? So even though all offenses are bailable, you must satisfy certain conditions.
And that's where most of the times the challenges are. What are these conditions that must be satisfied?
Okay, so the first thing you must demonstrate to the courts is that you appear to stand trial.
That whenever you are needed, you come.
So the court must be satisfied that if I allow you to go home, next week, if you are needed in court, you come voluntarily. You don't have to issue bench warrants for your arrest. That's the first thing that you must satisfy the court.
Okay.
That you appear to stand trial. You will not abscond.
Okay.
You understand that? That's the first thing you must satisfy the court. That you appear to stand trial. So the conditions that the court will consider, whether to grant you bail or not to grant you bail, is whether you appear to stand trial. 2, will you interfere with the witnesses of the prosecution? So there is, I don't know whether it's 3 or 4 years ago, where some 5 students of K University, right, had sex forcibly, allegedly, with a student. I was in court when their lawyer applied for bail, and the High Court was reading the ruling for the bail application. One of the reasons why the court refused the bail was that the witnesses for the prosecution are students around Ayediase, New Side, where the hostel was at that time. And if I'm to grant this student bail for them to come back to the community, they may interfere with those witnesses.
Yeah. And that would affect how the process will go.
So on that basis, the court can refuse you bail. If there's a possibility that you may interfere with the police investigation. Sorry, the witnesses.
Okay.
Another instance where the court may refuse bail is whether you interfere with the police investigation. So sometimes, being a lawyer, sometimes you consider this. When you read the charge sheets and the facts, and the police indicate that they are done with their investigation, then it's very likely that you may get bail for your client.
Okay.
Because they say they are done with their investigation. But when they say investigations are ongoing, then things will become tougher for you.
Because there is a likelihood that you can interfere.
Bail, you interfere with police investigation. So the court will consider whether if you are granted bail, you interfere. So sometimes the police, if they want to mafia you, even though they say they are done with their investigation, they will still say that
they are not done.
They are not done. Investigation is still ongoing. I have a problem with Ghana's justice system when it comes to that. My point, you see, in some other countries, before they charge you for the offense, they should have done their investigation
already. Yeah.
So if you are not done with your investigation, why are you charging the person for this particular offense?
Exactly.
But Ghana,
they
will charge you. I
tend to agree with you.
Yeah, they will charge you for the offense
before they do their investigation.
But where I sometimes agree with them is the 48-hour rule thing.
Okay.
They don't want to grant you bail. Ordinarily, they should grant you bail pending the investigation. But they don't want to grant you bail. So they are forced to charge you for that any offense that they want to, any possible offense. Then they bring you before the courts and tell the court that they are still doing investigation. So you should be remanded.
So they find a way around that.
But other than that, I wouldn't have agreed with what they do. What makes me agree with what they do is because of that 48-hour rule. of the investigation. But in those countries, it will take months for them to do their investigation before they
effect. Yeah.
Even before they invite you, they will do investigation.
Exactly.
But Ghana, it's not like that. As soon as the complaint is lodged, they'll come and arrest you and continue the investigation. Where I think is very wrong. Because sometimes
your liberties are curtailed because by the time they are done with their investigation, perhaps they realize that it was a foolish case.
Yes.
But then you might have suffered for that already.
And even with that, it gives the possibility of investigation being tampered with, witnesses being influenced.
Yes. Because
the person will know, hey, I've been called. Then these are the possible witnesses.
Yeah.
Let me get people to influence them. But if you do
your
the investigation
and gather everything,
what will be left with what you hear from the
witnesses?
No, from the accused.
Person you are charging,
That after you hear from the person, you proceed and you charge the person. Like how we see in other countries. I think they should have a look at how they conduct investigation in Ghana.
In this country.
They shouldn't just arrest
before they start with their investigations.
Yes, because even though I've not really experienced what happened outside, we see them in movies, and movies reflect what they do.
Yeah,
they will do thorough investigation.
I mean, we can even look at Abu Trike's case in Ghana, for instance, for extradition and all that.
Yes.
When you read some of the statements and the charge sheet and all that, you realize that they've built a whole docket on the individual from maybe 2013 to 2015 before they move in.
Yes.
So by the time they come and claim this, you don't really have any excuse because they have enough evidence to nail you.
I think Yoko, NACOB, and OSPs developing that now.
Exactly.
It's the police who doesn't do that. But I think Yoko, they are doing that.
Yeah.
They will do some investigation before they
Raymond Acha and his team.
Yes, before they even call you. I think it's a good thing.
Yeah.
That the police should also adopt.
Maybe the police are not equipped enough to do that, but we wish them well.
Yes. So, as I said, one of the reasons is whether you interfere with police investigation. Right, whether you interfere with police investigation.
So we look at three of them. One is that whether you appear before court for trial.
Yes, the main one.
The main one.
And whether
you interfere with the witnesses. And the third is whether you interfere with police investigation.
Yes. And whether you commit federal offense when you are granted bail. Whether you commit similar offense. The court will refuse bail. So there are instances whereby the nature of what is happening, if you are to grant you bail, you are allowed to go and do the same thing.
So like you've beaten somebody and you've been arrested.
Yes.
Now you put you before court. Before say you do court, perhaps you were threatening the individual and say, "Oh, me babaka."
Yes. So
it's likely that when we grant you bail,
you commit an offense, the court will refuse bail.
Okay.
Right. Now we will go into what the court will consider.
Right, to grant you bail.
No, to determine whether you appear.
Okay.
Don't forget, I said we have the factors that the court will consider to determine whether you appear or not. So
yes.
Whether to grant you the bail
or not.
It's whether you appear, whether you interfere with police investigation, whether you interfere with witnesses, whether you commit federal offense whilst on bail. Those are the matters the court will consider to determine whether whether to grant you the bail or not. You see, the first one is whether you appear to stand trial.
Yes.
That one. We have factors to the court consider to determine whether you appear.
So it's not just as raw as it is.
No. Whether you appear to stand trial to has its own conditions. And now the court will look at the nature of the accusation.
Okay.
The nature of the accusation. The nature of the accusation. I have a problem with that one it's still being in our books. Because now you have made all offenses bailable.
So why is
still having the nature of the accusation or the nature of the offense?
Okay.
Do you understand?
Yes,
that?
I guess.
Because the nature of the offense was sent into the 96(7),
which says that certain things should not be
bailable. Yeah. Now all offenses are bailable. So I think they should reconsider that law, which provides that the court should look at the nature of the offense, the nature of the accusation. And I think the court consider whether you are paid to stand trial or not is the severity of the punishment.
The severity of the punishment. So for the offense, perhaps, which you are standing trial for.
So if you are charged for murder, now the sentence is life imprisonment, or treason or high treason. It's still punishable by death.
Yeah.
So you, this person, if we convict you, we are going to sentence you today. We are going to kill you. If we grant you bail, will you appear?
No, you run away. My Nana Tutu will run away.
Do you understand? There was a case that I was doing that. My client was charged for robbery for different in different courts.
Wow.
And robbery with offensive weapon, the minimum is not less than 15 years. So he knows that if he is convicted, he might get 15 years here, 15 years in it. So different courts, right? One of the reasons why the court didn't grant that person bail, right, for the robbery, even though offenses are available, is that anytime you pray for bail, the Attorney General Department will inform the court that he has another case in this court, another case in that court, which may compound his punishment. And don't forget, bail does not have maximum. So the court can give you 100 years, 50 years, 80 years for robbery. Yeah. I said bail does not have maximum. Robbery does not have maximum sentence. So the court can give you that maximum period. So the severity of the punishment for that particular offense shows that if you are granted bail, you may abscond, you may not appear to stand trial. So some of the courts will consider the severity of the punishment. Another interesting thing the court may consider to determine whether you appear to stand trial or not is the nature of evidence available. So the nature of evidence available, the overwhelming nature of the evidence available, shows the propensity of the likelihood of you being convicted. So, like you have been charged for murder, and there were cameras,
CCTV footages and all that, available. Sound, everything.
There were eyewitnesses available. All those pieces of evidence have been made available. It means that you are likely to be
going in.
So you also know that this offense there's no way you'll be acquitted in this charge. So when they grant you bail, it's not likely you appear
to stand trial. Yeah.
But it's offense that you know that they don't have evidence. You know in your head that you have committed offense, but you know they don't have evidence. So that one, when they even filed their disclosures before the court has realized that they don't have really evidence. They may rely on circumstantial evidence, which may have a higher burden. So if the evidence is evidence against in respect to the accusation, it's not overwhelming, it's not that well cemented, then the person knows that one or the other he may be acquitted. So he may appear to stand trial.
So basically, like on the face of the evidence available,
yes,
it's likely that they wouldn't have anything to pin you.
Yes.
So then, okay.
So you are not afraid. Or where you know very well that you have not done the act.
Yeah.
You know very well that you have not done it. Then you know that if justice is served properly, you will not be convicted. Then you appear to stand trial. Another thing the court consider whether you appear to stand trial, do you have a fixed place of abode? That if you are looking for you, you find you.
They be added down now for phone chain.
Oh, they will not grant you bail.
Because that
is so. And another thing too is that if the police struggle to arrest you, right? If they bring that before the court is likely not to grant you bail.
Because they don't want to go through that same process again.
So sometimes if a client calls me that, the police has invited him or her, I tell the person to go. If they invite you and you go yourself
voluntarily,
and they grant you bail, when we go to court and we are praying for bail, you will not struggle. Don't forget, if the police grants you bail, when you go to court, you have to pray for bail for you. That one, the police will agree that he's not a person of flight risks and all that. But if you made the police suffer,
they will oppose your bail.
They will oppose your bail and inform the court how they struggle to get you. So it means that if the court grants you bail, they'll struggle.
Yeah.
So I always tell people that when the police invite you, go voluntarily, cooperate with them.
Okay.
That one, we will let the court know that when you were even invited, you went yourself.
Yeah.
And sometimes, even when the police granted you bail, you fulfill the bail conditions at the police station. It means that when you are praying for bail for you as an accused in court, it will not be difficult. Other than that, it will be very difficult for the court to grant you bail. So whether you have a fixed place of abode, whether you are gainfully employed, do you have investments? So those who have businesses, investment to protect, they have. It's like when you are being granted visa, they will find out whether you return. They will ask, do you have any employment? Do you have any property? Are you married? Do you have kids? Yeah,
because you may not want to run away and leave your family and your business,
your kids and all that here. So the court will consider all those factors to grant you bail.
So it means a lot of things are really considered in whether the courts will grant bail or not.
Yes, a lot of things are considered.
So it's not like, the politicians sometimes make people believe that, away the money bail and the other person don't only grant bail.
The court consider so many factors. The court considers so many factors. And if you go to a court where the court is assessing bail, like really where the parties are arguing. The parties will argue on all these things I'm highlighting. And the other side will also oppose on all these things for the court to assess.
Wait.
Yes.
Interesting.
Are you gainfully employed? Do you have even those who stand in as surety for you? Do you have someone to stand in as surety? If you don't have anyone to stand in as surety, because don't forget, the surety will impose a condition to ensure that you appear.
Yeah.
So if you don't have anyone to stand in as surety for you, then the court will not grant you bail.
So it means that obviously you can't be trusted. That's how come nobody even wants to stand in as surety for you.
No one trusts you.
I've seen people appear in court and then maybe they ask, now I'm away. As in, I'm also in the machimbo.
And I'm coming to speak to you. So when I can't say anything, I saw it.
Yes, because when I end you in the cross to me, how much more should the court then grant you bail?
Grant you bail. And there are instances where which I will discuss very soon. That people have been granted bail, but no one has signed as sureties for them, so they are still in custody.
Oh.
So they don't have lawyers, but the courts will look at, this offense is a misdemeanor. Because don't forget, we said the nature of the offense. So there's not a first degree felony, it's not a capital offense, it's just a misdemeanor. The court may grant you bail whether you pray for it or not. But having been granted bail, no one has come to sign as surety.
Wow.
That's where, in that case, if you are of good behavior, you are cooperating with the police, and you're a good person at the police themselves can come to the court and pray that the court varies the condition and take away the surety so that they can release you. But if you're giving them hard time there, then you'll be there.
They'll forget about
Some investigators are very good. They are very fair to accused persons. They know that this person is very humble, this person is very calm, the person has been cooperating, the person is very respectful, and has built trust with the accused person.
Yeah.
They can come to the courts, even though you don't have any lawyer present, they will pray to the court for the court to vary the bail conditions for you. So if that happens, then it means that you may be released on bail. So the court consider all these conditions, right, to determine whether you appear.
That's the first one.
Yes, the first one. Now, there are other factors that are not in the Act 30.
Okay. They are not written in the Act.
In the law. But the courts, by decided cases, have established that there are factors that the court to consider whether to grant you bail or not to grant you bail. So the first one, the next one is, or the ones that are by practice and by cases, is your own security as an accused person. Your personal security as an accused person.
As in your safety.
Your safety. So there are instances where, for example, the guy who is alleged to have killed immigration officer and put the person in the fridge. You see, when they are taking him to court, how the people around attack.
Yeah, the community is always on him.
Attack. And even the Majua issue.
Yes, the police officer.
When they're taking the person to court, how the family of Majua and the people in the community follow and attack the person. You see the prison officers and the police protecting that person, right? So assume that such a person has been granted bail and is in the community.
To go back into the community.
Pending the trial.
They might end up hurting him or killing him.
So sometimes the court will consider your own safety as an accused person and refuse bail.
Oh, do the courts normally tell the accused person why they are refusing?
When they are reading the ruling, they say that that because the public or the family or the others do not hear and they don't understand the reason behind that, they try to say the court has refused bail. So there are even instances where your car will hit someone in the township and the person will die. When you report the incident to the police yourself, the police will put you at the counterback for some time. Yeah. To calm tensions.
Because one of our boys now around the crab ball.
They'll kill you. There was a particular incident where an Uber driver was killed by a passenger. Ooh. He cut the Uber driver's head. And they arrested the person. All the Uber drivers in Kumasi drove their vehicle to
the station,
Kumasi Central Police Station, that they should release the person. The person that is the suspect, they should release the person. So let's assume that they take the person to court and the court grants the person bail. And the person comes back. Because when you come back to the community, the protection the prisons or the police will give you, you won't get the same protection when you're on your own.
And that makes a lot of sense.
Yes. So for your own personal liberty or safety, personal security and safety, the court will refuse to grant you bail.
Interesting.
The court refuse to grant you bail in respect of certain offenses. Another factor that the court may consider to grant or refuse bail is the confidence of the public in the justice delivery system. The confidence of the public in the justice delivery system. So, let's say there is an alleged rape in a community or defilement in a community, and the community has heard that, the person who did the act has been arrested, or you are known to be a thief in the community, you have been stealing people's things, and now they've caught you. All the community or the members of the community will come to the police station. You're
They'll be excited about that.
And the public mostly think that if you are granted bail, you have been freed.
Yeah.
So if you appear before the court for the first time and the court grants you bail, the public will lose confidence
in the courts.
Oh, they have taken bribe. The judge has taken bribe. Case ni foolish case. You understand? So in respect of matters to protect the confidence of the public, so that the court will see that people are around.
Yeah.
There's a very sensitive case. This is a very high profile case. The court will not grant you bail. So sometimes the court can call the lawyers and the AG to the bench and explain that, you have been able to satisfy the conditions, but you have to protect the confidence of the public.
Public in the court.
So it's too early in the day for bail. Let's wait for some time.
Oh, okay.
Because ebejo.
Interesting. These are more like court secrets that you are sharing with us today.
So the court will consider all these factors because the public there was even sometimes someone called me that Dennis, I lodged a complaint at the police station, and this person who did this to me, the court had granted him bail. Does that mean he a jana? And I'm so there be. Is bail pending the trial?
People assume that once you are given bail, you are granted bail.
Yes.
Case not a foolish case.
Yes, the person has been freed. And so they also even think that if the person is granted, it means that you don't have a case. Okay. Case. Yes. So I was doing a case for a client, and the reason why my client wanted to get bail for him, like try and get bail for him, is because he told me if he's in for long, the people outside the community will think he has done the thing.
Yeah.
Will assume that he has done it, but he has not done the thing. So in order not for the stigmatization to prolong, if he comes out, then they will believe send the wire the so that's why he wanted.
Interesting.
And we're able to get a bail for him. You understand that?
Yeah.
So for the confidence of the public in the judge delivery system, the court may
refuse to grant bail.
Because don't forget, the bail is your personal liberty, right? But the public interest outweigh your
public interest.
The public interest outweighs your personal interest or personal liberties. So, if considering the circumstances, the public interest must be protected as against your personal liberty. That will be done. Because don't forget, I said, and Article 12, Clause 2, your right and freedom is not absolute. It's subject to public interest.
That's how come there are public policy directions on certain things. It might affect your personal rights and your personal liberties, but for the interest of the public
generally, that will be respected as against your personal liberty. Sometimes the court will grant you bail based on health grounds.
Yeah.
Based on health grounds. You are very sick. The kind of treatment that you want, maybe it must be provided outside the country. Maybe you may have to undergo some form of surgery. Maybe the nature of your sickness. They may have some sick bay, or the police can take you to the hospital. But to get proper treatment, even your way of living, the food that you eat, where you sleep, your condition must be properly provided. Because we are all aware that the conditions at the prisons and at the cells are not the same as when we are home. So sometimes the court will consider these factors, and if you are very, very, very sick or very ill, the court may grant you bail. Right, pending the trial. May grant you bail pending trial. So the court consider all these. And so if you remember when Kwajon Cancer ran someone down with his vehicle, the court granted him bail because he was not well.
Yeah.
Right, because he also was in a wheelchair and all that. But what was very interesting to me was that he also went to
the event, the movie premiere.
Yes,
he passed there briefly.
Yes, so something the court to consider health grounds. Another factor the court consider is if your trial has prolonged unreasonably. And Article 14, Clause 4, it provides that a person who is being tried, right, must be tried within reasonable time. It's also an Article 19. If you are not tried within reasonable time, you must be released either conditionally or unconditionally. That is why sometimes if the trial is taking long, they are not trying within reasonable time, the court may strike out the case for want of prosecution. Aside the court striking out the case for want of prosecution, your lawyer can also, based on the long trial or the long period the trial has taken because of the delays, to pray for bail.
Okay.
So if the trial has unduly delayed and the punishment is one that it may even be it's not that long as compared to the period that you are spending in custody, the court may consider the period, the delay, and grant you bail. So these are factors the court consider whether to grant you bail or not to grant you bail. Now, the granting of bail is also subject to conditions, right? The condition may be self-recognizance bail or bail subject to surety. Self-recognizance bail or bail subject to surety. The self-recognizance bail is where you, the accused person, will personally undertake or promise that you appear before the court. And personally, there are certain high-profile persons in a country that I believe when they are arrested or when they are being investigated, they must be given self-recognizance bail. Because they will not go anywhere. Like, for example, if, Dr. Mount Belmia is being arraigned before a court, right?
Yeah.
He must be granted self-recognizance bail. Because
I mean, there's too much.
He wants to run for president.
Exactly.
Where is he going
There's too much to lose when he runs away.
So those people, he doesn't need surety for the person to come and justify anything. The person will be here.
Yeah.
There are people who have huge investments in the country. Where are they going to?
They can't run and leave those investments.
For example, Professor Frimpong Boateng was before a court or some time, and I don't know whether it's Yoko or OSP or a court, and his bail was subject to conditions. So this man, he will not go anywhere.
Well, maybe they assume same.
Sometimes the person's pedigree. You may trust that the person will not abscond.
Yeah.
Because of the establishment in the community, their connection with the community and all that. So self-recognizance bail is granted to persons in a way that they will not bring in any third party. They will undertake that whenever they are needed, they will appear
before. Okay. So then we move to the surety.
Then the surety is where a third party will come and impose bail on your behalf. And that is where I said that surety, there will be a bail sum to be paid. Ghana, that you don't pay that amount.
Yeah.
And in respect of that particular amount too, they impose that amount in respect of the subject matter of the charge.
Or the investigation.
The investigation. Right. So if you are being charged for embezzlement, for corruption, and the amount involved is 1 million Ghana cedis, 20 million Ghana cedis, 50 million Ghana cedis, then your condition, the amount that they will quote will also be 50 million Ghana cedis. Because if you abscond, then even though criminal trial is not for money, if the person is to pay the bond, then the bond that will go to the state should be that sum. The fine that should go to the state will be that sum. You understand that?
Yeah.
So that's how it works. So it's not as if they just sit there and they
put any figure.
No. Like what people think, right? So I don't know whether when they said Miraculous Abaju was being investigated for 50 million Ghana cedis, I don't know whether they quoted 50 million as the bail sum. If they did, then it commenstrates the subject
that's the figures they were quoting, and they had to.
Yes, that's what happens. Even in court, that's what happens. Okay. So it's not only Yoko who is doing that. Even in court, the court will state an amount which commenstrates the value of what you are being investigated, subject matter of the charge.
So then, sorry to cut you. So then it means that when we hear some of these things in the news and people are being sensational about it, we just need to pay attention to what the facts are.
Yes.
So that at least we can make reasonable deductions from them.
And the good thing is that the person is not required to pay that amount then. But what becomes a problem is that, as I've already explained, at first, if the surety is not able to pay that amount, he was being imprisoned for 6 months. Now, it is no more imprisonment. It means that if you're not able to pay the money, you should go scot-free.
Yeah.
Then again, that becomes a problem. So they say that then come and justify that you worth that 50
amount.
million Ghana cedis. So bring in property documents, whether landed property or movable property, or it should be someone who earns that amount as salary, so that we can deduct if you are not able to bring the money. So that's why they provide those justifications. Show that you worth that. You can provide that.
Interesting.
So it's not to actually punish the person. It's not to actually make sure the person does not get bail. The conditions are not set to punish. Because under Section 96, Section 4, the court should not refuse bail as a basis of punishment. You understand that? So these are the conditions
that must be met.
So it is not simple like that.
It's not as flat as people assume.
No.
That, your copay bill, your money bill is just a simple process. It goes, a lot of things are considered.
Sometimes, personally, I believe the court grants bail easily. Yes, because that's what I believe. Because if the court is to assess all these things,
maybe the judges in their mind have actually considered all those things before.
Some of the judges are bail oriented. I always say that the law lies in the bottom of the judge. It's their discretion. So some of them believe that let me grant bail. Right. Some of them too, no matter the situation, they wouldn't want to grant you bail, which I think is wrong. The bail should be granted in respect of the law. Right, it should be exercised judiciously in accordance with the law and all that. So this is for bail pending trial.
Now the next one definitely has to do with bail pending appeal. So you've been convicted.
Yes,
you've been sentenced. Now you have the right to appeal. Just like Chairman Wontumi is doing now.
Yes. So Chairman Wontumi has been convicted and sentenced.
Yes.
Now he has appealed against the conviction and the sentence. During the pendency of the appeal, he may apply to the trial court that tried him or the appellate court for bail. Section 33 of the Court Act provides that.
Okay.
So the trial court or the appellate court, he may apply for bail pending the appeal. Now, that one is not automatic, right? So even though the court exercises discretion, there are certain conditions that must be satisfied. The court will consider your application vis-a-vis those factors.
Conditions.
Those factors. If we're able to satisfy those factors, then the court is ready to grant you bail.
Let's look at Chairman Wontumi's case, for instance. Just supposing that with the factors that has to be met. Okay, so what are these factors?
Okay, so the first one is there must be an exceptional ground or circumstance for the application. This factor doesn't go into the merit of the case.
Yes.
Right? So there must be an exceptional ground. Oh, Chairman Wontumi is very sick. Chairman Wontumi is very ill. Maybe there's something happening. Right? Exceptional circumstance to warrant the application. Okay. If you are able to demonstrate that, the court may grant you that. There's another factor. That one goes into the case itself. The appeal that you have made, right, on the face of your record of appeal, vis-a-vis the judgment that the trial court gave, there must be a good ground of appeal. What it means is that the appeal should not be frivolous. On the face of it, it must be clear that the conviction and sentence is wrong in law. Right? So sometimes if you take a judgment, a judge or a lawyer may say that, this conviction is wrong.
Yeah.
It doesn't sit well with the law.
Considering the facts and the laws, so the person shouldn't have been convicted.
Yes. So on the face of reading the judgment and then on in respect of the grounds of appeal, right, the court must come into the conclusion that the conviction and sentence is what?
Wrong in law.
On the face of it. It must be clear. But if you are able to demonstrate that you have exceptional ground for the application, or the conviction and sentence is very wrong in law on the face of the record, right, then you may not, because your appeal is not likely to succeed. Why should we grant you bail pending the appeal? Right? Because you must demonstrate that the appeal has a likelihood of success.
I remember once going to court, Her Ladyship Dorinda Smith, and then a lawyer had said that he was going to appeal the decision that she had taken.
Very well.
And then she told him that, listen, counsel, should I tell you something? Should I tell you why your appeal will not succeed? And then had to educate the lawyer right there in the court. as to why the appeal will not succeed.
Yes.
So that he wouldn't have to worry his head to file appeal.
Yes. So sometimes you see that the charge or the evidence supports the charge.
Judgment. Yeah.
The evidence supports the judgment. Very clear.
It's right on the surface.
Yes, it's not very likely that your appeal will succeed. So if it's very clear, then you may not be able to get bail pending appeal. But if we're able to demonstrate, if any third party with proper legal eye sees the evidence, the judgment, the record, and say that this one, the appeal is likely to succeed. Then the appellate court or the court may grant you bail pending appeal. Another factor the court may consider is whether by the nature of the offense that you were charged and convicted, you need adequate and ample time to confer with your lawyer, right? Because by the nature of the case, the lawyer may not be able to be with you at the prisons, prepare appeal properly and defend your case. The court may grant you bail pending appeal. So that's also a factor the court consider. And the interesting one that the court mostly considers is whether, based on the nature of the sentence, right? If we don't grant you bail, by the time your appeal is heard, you may have completed the sentence. So that if you are acquitted and discharged, it means that
you've wasted time.
So, for example, you were convicted for 3 months imprisonment. So you were convicted and sentenced, for 3 months imprisonment. Then you appealed. When you appealed, even preparing the records of appeal and forwarding them to the appellate court may take more than 2 months or 3 months. Right? So it means that if you don't grant you bail pending your appeal, you may serve the 3 months before the appeal.
The appeal is even heard.
The appeal will be moot. There will not be any need. Just that the most important thing is that when you appeal and you continue the appeal, even though you have served a sentence, when your conviction is set aside, it will be cleared
of the records.
You will not have a record to be a convict. Right? That's why people will still go ahead and appeal. Even though they have served the sentence. Another thing that may delay the process is not only the creation of the record, sometimes legal vacation. Judges and lawyers have legal vacation, long vacation for 2 months. That's from the month of August to September. So lawyers and judges go on vacation. So in that case, the High Court, Court of Appeal, Supreme Court, they don't sit generally. Just that the High Courts, certain judges will sit for certain matters permitted by law. But Circuit Court and District Court, they don't go on vacation, so they sit. So it means that if we are appealing your case from the High Court to the Court of Appeal, during the month of August and September, you wouldn't have any judge to sit on your appeal. So it means that case, if it's 2 months sentence, you may serve
the entire period before.
So based under those circumstances, if you apply for bail pending appeal, the court may grant you a bail. But don't forget, the court to consider all
these factors.
If you're on the face of the record, your appeal does not have a likelihood of success, then even though you may serve the period, the court will still not grant you bail pending appeal. So that one is not easily granted as well, right? So we have 3 main forms of bail: police inquiry bail granted to a suspect, bail pending trial granted to an accused person, and bail pending appeal granted to a convict. So at every stage of the criminal justice delivery system, there's
an opportunity for you to seek for bail. Interesting.
As a suspect, as an accused, and as a convict.
So Chairman, to me at the moment sits as bail pending appeal. Because he's been convicted and sentenced.
Yes.
And that's what they are trying to appeal.
Yes. The interesting thing is that he's on bail for his other offenses.
Other offenses. Yes, but
just that he has been convicted
for another
so he
one.
has to be in.
Interesting. The law is very interesting if we decide to pay attention to it and follow the matters as they are. And one of the very reasons why we do this is just so you also get to understand what goes on in the system, so you don't sit back and join the masses when they are just being overly sensational and just, politicians, for instance, get to politicize everything. And I always have a problem because the requirement for lawyers when it has to do with some of these discussions, the bar is quite high.
Yes.
But when they find themselves in politics, they tend to lower it and tend to just
play politics with it. They know the facts.
Exactly.
They know, but at least they must do politics with it for those who don't really understand, to see that the other side is doing something that is not lawful. But I believe that for the sake of public awareness, right, they shouldn't play politics when it comes to law.
Exactly, and that's one of the mandates or the requirements of a lawyer.
Yes.
Just like you are doing as part of the service, public education is part of the things that because you are required to do.
A lawyer owes a duty to the client, a lawyer owes a duty to the courts, a lawyer owes a duty to the public.
Exactly.
You understand that? So if you are a lawyer and you're also a politician, it's very important that you draw the line.
You find a balance.
Yes. You find a balance, and you don't do politics with everything. When it is the truth is there,
it's quite clear.
Quite clear. You have to say it. I remember I've not gone into it, but someone made a comment that the opposition party gets angry when issues of, I think, a particular lady has been
set in a tamaklu.
Yes. So when the opposition party is making noise, then someone will say, "Go and read the judgment." They get angry. He said that MVP gets angry when someone says they should go and read the judgment. They don't want to read the judgment to know the reason. What all that they know is that they are doing selective justice.
Yeah.
But I think that if you read the judgment,
if it's sound, you know.
Sound, you should agree. You shouldn't do politics with it.
Yes.
If it's not sound, you know.
I mean, I've heard some of the politicians who initially who had until they read the judgment had their own opinions. They were angry. Everybody was angry. I have a friend in.
But I think if you don't read the judgment, that's what you would think that
exactly
when
he's been convicted already. So how come all of a sudden?
And I think also people didn't know there was even a appeal ongoing.
Exactly. You know, for me, I have a friend, Patrick. Patrick is in Canada as we speak. Patrick had done a live video. So angry, he was so mad. Like, listen, this person has stolen money. The person has been jailed. And because her party is in power, the person has actually been let to go free and all that. And so I left a comment on his post and I said, Patrick, I can see you are very angry. Have you read the judgment or anything? He left a comment and said no. So later in the day, he called me and we spoke. And I broke down the ruling, the judgment and everything. And he became sober. He now understood the grounds for which he was actually, acquitted and discharged. So I think sometimes the challenge is that not everybody will have the time to read. That was a 94-page document. Not everybody can read it. And even if they read, even though these judgments are supposed to not be full of legalese so that everybody can understand, not everybody would understand.
Yes.
So we owe, for me, I'm not there yet. You owe it.
We owe a duty. but we see, before you educate, the people will just, but you see, to be fair, if you look at the political indicators, as soon as you hear something like that, that's what you say.
Exactly.
That's what you say until
you pay attention and read.
Until you pay attention and read. But the law is funny. The interesting thing is that the public only knows the general rule.
They do not know the exceptions. And that's where the lawyers are there.
Yes.
Yeah.
So the exceptions is where you see the things, like the nitty-gritties, but the public is not aware of that.
That's how come they say that lawyers lawyers like lying.
Yes.
They don't know that there are exceptions to most of these rules.
They don't even know that the accused has not been any burden of proof generally. The burden is on the prosecution. So they don't know why someone is alleged to have done this and the person has been acquitted and discharged. Right? But they are defenses. They are defenses. They don't even know you have something called self-defense. Why is it that Dennis shot Kwesi and Dennis has been freed?
Because we saw him shooting him.
Yes. But they don't know the circumstance. And I heard the gunshot came up and all that. So I think what is important is that we should always try as much as possible to educate the public, and those who are literate and are capable of reading, they should always read before they speak. Even if they hear anything, they shouldn't take it
they consume everything just like that.
They should go and read on it themselves so that they will be fortified in their belief and they will really understand whatever is going on. So that we all, now, education is not only about when someone tells you, you can also read.
Verify by reading.
Most of the things are put online on social media. You can always download and read so that you get the awareness and education on it.
But of course, as you do that, just make sure that you are getting them from the right sources, because now social media is awash with all kinds of information. People are just passing commentary be mindful who you are following, be mindful who you are reading from, and be mindful the sources you are also reading from. That's something that I will say as we wrap up. But thank you very much for spending time with us on this particular show. It's been very insightful, and I'm pretty sure you have enjoyed this as well. If you want more of these, please. His time is very expensive, so we need to make money, and so that we're able to pay him to make more time for us. But we are really, really grateful, and hopefully we have more episodes on this particular show. So there you have it. Maybe there's something you want us to talk about. Drop your comments. Let us know what subject or what topic you want us to speak on next, so that we will actually prepare and come and give that education. My name is NYDJ. It's been a pleasure serving you on BTM Afrika, and big shouts to my producer who's working things behind the camera. That's Nana Tutu. We shall be back on this same channel. If you've not subscribed yet, please make sure that you subscribe, drop your comments, share with others, so that they get to know all the good things that we bring to you on this channel. Thank you, and see you some other time.
Savani Music.